Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center here in Boca Raton, Florida. This is episode 97 of Business SOS. We're only 3 episodes away from episode 100. I'm very excited about that as I keep talking about getting close to episode 100. It looks like it's going to be closer than we think. So I'm very excited about today's episode because I think it is important to you if you're in litigation or you anticipate being in a litigation. Cases obviously are won or lost. And I remember listening to a mediator some time ago talking about in a court proceeding or in a trial, there will be a winner, there will be a loser. There's really no in between. There's no draw. Somebody's going to win, somebody's going to lose. The question is how much and whether or not the parties will resolve the matter beforehand. Sometimes the cases are lost before because of the clients, and that's the reality. Clients sometimes make mistakes. So I want to talk about that today. Today's topic is top mistakes that can sink your case. So I want to talk about that, and you will see some recurrent themes that I have discussed in the past episodes about mistakes that people make and their positions, mistakes at trial. This is a compilation of some of those mistakes. I think it's important to put it into one podcast because it is important to know that when you're in a litigation, there's a partnership that is being made between you and your attorney, and a partnership, by using that term very broadly, but you're working together with your attorney, and your attorney needs your cooperation. Your attorney needs your assistance to be able to advance his or her case. So I want to talk about really more from the client perspective, what you as a client, should avoid doing or should not do in order not to make an unavoidable mistake and lose your case as a result of that. And sometimes some mistakes are minor mistakes, some falls that you can get over. Some mistakes can be fatal to your case. So I want to talk about some of that today. I want to talk, the first one is not responding to the lawsuit or court deadlines. And it happens more frequently than you think. Often somebody gets served with a lawsuit. Usually when you get served with a lawsuit, you have 20 days in Florida State Court to file a response to the lawsuit. It could be as simple as a single piece of paper saying that I need to get a lawyer. That will avoid the default, the clerk's default. And in federal court, I believe you have 21 days. But I get people call my office 30 days after the lawsuit has been served. And at that point, we're scrambling. At that point, it's an emergency, and we have to find a way to talk to this potential client because when I, get the call that the paralegal does the intake and say somebody got sued, then my second question is, when did the client get served? Because then I can assess the sense of urgency as to when to speak to the client. So if somebody gets served yesterday, I know I have 19 days, so we can schedule the appointment for tomorrow, the next day, okay? And we can talk about it. So, well, it got served 30 days ago, over a month ago, and there's some motion for clerk's default. That becomes an emergency because you have to address that immediately before that clerk's default gets entered. So it happens all the time. People go on vacation, they get served, or they just say, I was busy, I didn't have time to do this, I was working. So if you receive a lawsuit, you have to prioritize that lawsuit in your day. You got to make that a priority, and whether getting an attorney, that has to be a priority, and your to-do list has to move up because the clock is ticking every single day that passes, and you're trying to coordinate with various attorneys to interview. So don't put that aside. It becomes the most important thing you got to do the next day once you get served, you get noticed with the lawsuit. The same applies to not meeting court deadlines. And I've talked about discovery deadlines as well. let me talk about those first. If you get served discovery, interrogatories, request for production, request for admissions, along with the lawsuit, you usually have 45 days from date of service to respond to that in Florida State Court. If those discovery documents are served after the lawsuit has been filed, then you have 30 days. We have a calendar that I like to have everything within 15 days from the client, and 20 days and 25 days gives us time to review it, do some final edits, have the client review it again and send it out with a 25th day, as opposed to waiting for the day that it's actually due. What happens often to us is that we have the client for information. I say, we need this in 2 weeks, and we don't get it. We don't get the information, whether the answers to interrogatories, the documents that are requested in their production request, and 2 weeks pass, nothing happens. We go back again and say, listen, we need these documents so we can respond to your request for production of documents. We need the answers to the interrogatories in your own words. We'll go with them with you, go over them with you, and we need the admissions. Nothing happens. So at the 25th day when it's due, sometimes we get something, or we have to say, well, this is due in 5 days, we need it now. That's when we get it, if we're lucky. Then we have 5 days to get all the production requests done, and then we have hundreds of documents, all disorganized, without any type of order or formatting, and we need to figure out a way to match the actual document, the document that has been provided to us, to the production request. And there's just not enough time, depending on the volume of documents. So inevitably, we need to ask for an extension of time. For counsel, as a courtesy, sometimes they grant us 10 or 20 days to get this done. But when that happens, then it's more cost to the client, because then we need to ask for an extension. We need to get an agreed order in place. We need to communicate with counsel. Those are things that can be avoided by meeting those deadlines and following your attorney's instructions. Usually it's a paralegal that reaches out to you as a client, because asking you to provide these documents, the paralegal prepares that first draft of responses, then the attorney reviews that draft and begins to refine it to make sure that it's properly answered. Requests for admissions are very important, and those can be done in a matter of 5 days tops. What you got to do is admit or deny or without knowledge. Okay, there's not really that much of a science here. And most of them are denials anyway, with the exception of some items that are obviously true. But the problem with requests for admissions, if they're not responded to within 30 days, within the time allocated pursuant to the rules of civil procedure, those submissions can be deemed admitted. And then we have to scramble again. Ask for an extension of time for counsel to give me an extra 10 days to submit the request for admissions, to avoid those admissions being admitted. So the lesson I'm telling you here is that you have to respond to your attorney's request. Make yourself available. The attorney's very busy. If the attorney's asking you to provide some documentation, some information, provide it. Cooperate. If you need an extra day, that's fine. But you're holding back your attorney if you don't cooperate and provide information that he or she's requesting from you to help your case. It is your case after all. Or if you're providing complete answers to interrogatories, don't provide complete responses. Those things can affect your case. Another deadline that I think is important to know is that sometimes attorneys withdraw from cases. And if you have a business entity, as I've mentioned before, you're required to seek counsel to continue the representation, especially in circuit, anything above small claims, you need an attorney if you're a business entity. So, and usually we have in some of the orders of withdrawal of attorneys, you have language that states the following, that the corporate defendant must have an attorney and has 30 days to seek counsel and the attorney has to file a notice of appearance. There's also language to the extent that the individual defendant has 30 days to notify the court if he or she wants to continue the case pro se on your own. Those are important deadlines to meet. If they're not met, if you don't send in something to the court that you want to continue the case, or if on your own, defending your case on your own, or an attorney doesn't file notice of appearance, the other attorney can file a motion to strike pleadings, motion for sanctions, and you pretty much can lose the case by not meeting that deadline. So it's important for you to read whatever the attorney is sending to you. If there's something that you have to do, to put in your calendar so that way you meet that deadline and you don't miss it. Mistake number 2, and I've mentioned this one before, is withholding information from your attorney. It happens all the time. It is important to tell your attorney the good, the bad, and the ugly as in your case. Nobody's perfect. Okay, you're not here to be judged. You're here to be helped. So to the extent that if there's a piece of information that you know about your case, a conversation that took place with the other party, with the defendant or plaintiff, a conversation with a witness or a witness that was privy to a conversation that can help your case or hurt your case, let your attorney know. Because the worst that can happen is that that piece of information shows up on a deposition and your attorney is blindsided, that was not aware of the existence of an email or a text message that could hurt your case or be detrimental to you. So it's important for you to let your attorney know everything. And even if you, at times, you remember later, just let your attorney know. The last thing you want are surprises at the deposition or a trial. So just reveal everything to your attorney. Your attorney will decide how to handle that piece of information, whether it's fatal or it's basically inconvenient. But let your attorney make that decision and how to handle that, as opposed to finding for the very first time that an email exists, that you admitted some type of liability in your case, and then all the work your attorney did was for nothing. There's some things that attorneys can overcome, but some things that attorneys cannot overcome if by any chance you made some admissions that could detrimentally harm your case. So just share everything so that way your attorney can decide how to handle it. Mistake number 3, destroying or altering evidence. We also call it spoliation of evidence. I will tell you that that doesn't happen that often, but it does happen. It is important not to do that. It is essential not to do that. It'll come out. Okay, if there's information that, if there's two-way communication, somebody else has a copy of it. So it's never a good idea to delete documents, delete files to avoid some potential liability. I think that once you're in litigation, you need to preserve all documents, anything related to the case, and the other party has the same obligation. If you do that, you can have negative inferences against you. You can have the pleading stricken. You can have sanctions. It's just never a good idea to do that. So that's a mistake that some people make. I have not run into that issue, fortunately, but it happens. So I think that it's important to know that once you're in litigation, do not delete anything. Just basically preserve it and let your attorney know the information. The attorney will decide how to handle that piece of information or documents. This includes email communication, invoices, modification of documents. I cannot stress that enough, that you should not do that. Mistake number 4, being overconfident or uncooperative. This goes into depositions, applies to mediation, and applies also a trial. I will talk about deposition first. You're in a deposition. It is an adversarial process, but it's a professional process. So if you're a witness, you're the party being deposed, it's important to be prepared, to read the documents that are related to the case, meet with your attorney beforehand and prepare for that deposition. Your attorney will prepare you the types of questions that you will most likely be asked, and you know the answers because you were part of the case. And the objective of the deposition is to obtain evidence to be used at trial, most likely against you. So it is an adversarial process, but it's a process that is professional. So being antagonistic to opposing counsel, being disrespectful to opposing counsel, being sarcastic to opposing counsel, it's not going to help your case. I understand that you might be angry. I understand you don't want to be there, but if you're the one suing, they have the right to take your deposition. If you are the one being sued, they have the right to take your deposition. It is part of the process of gathering evidence. So in terms of professionalism, I cannot stress that enough. We can disagree, but still be respectful. And the reality is that it does not help your case whatsoever being antagonistic to opposing counsel. Clearly, if you do not understand a question, just ask the attorney to clarify the question. But things will go smoother just by answering the questions on a factual basis without getting into a personal tit for tat with the attorney. It's just not helpful. It's make the deposition longer. It does not look good in the transcript of the deposition. And remember that when you have a deposition, you have a co-reporter who's taking the transcript of your words. In some cases, you have depositions that are video depositions, which are recorded, and that recording can be shown in court for impeachment or for any other purpose. So your demeanor at that deposition becomes very important, how you present yourself, especially if it's a jury trial. You want to be as credible as possible. You want to be professional. You want to state the facts with confidence, but without arrogance. So it is important to do that. If you're at a hearing with the judge, evidentiary hearing or a trial, I'm going to combine those two. I cannot stress that enough. The same thing applies. It is a professional setting. Being antagonistic, being sarcastic, being adversarial in a way that you're confrontational, it's not going to help your case, and the judge might have a negative impression of you. It has happened to me a number of times in hearings that the clients get very agitated for the right reasons. They're upset. They're in the middle of a lawsuit. They say, some things. The judge get upset. The judge remembers you. I really do not want the judge to remember you at all, okay? Especially if you get under the judge's skins for something you said. And also, more of an aside, if you're going to do an evidentiary hearing, you have a hearing, you have to appear. It's important to appear, whether it's at your home or in a professional setting, but don't do it from your car. It just does not look good, especially if it's your case. You're sending the message, this might not be important to me. Do it from a place that you can actually be quiet and have the right setting. I think also another point that I like to make sometimes with challenging your legal team, challenging the attorney's strategy, it can actually become an issue as well. You hire us, we're the professionals, we've done this before, we do this every single day. And what happens is that sometimes, the clients speak with someone they shouldn't in the first place, could end up just not become attorney-client communication, or there'll be something in the web. And then they try to second-guess the attorney's strategy. It is important to be on the same page with the attorney as you're going with the case. It's very, very important. Again, professionalism is extremely important when we're dealing with court proceedings. Mistake number 5, which is kind of begin to touch upon that, is not following your attorney's strategy. I mentioned a few podcasts ago that, listen, attorneys, we have access to the same law. We have the same legal libraries. We all use pretty much the same legal libraries. We took the same coursework for the most part. We have the same law license. What makes us different is our ability to utilize the law and the facts and our creativity in order to solve the case. That's what separates us. So, and we develop a roadmap based on the facts that we have at the time. But roadmaps can change based on new information that come in. The strategy continues to evolve all the way to trial. So it's important that you and your attorney communicate about the roadmap. What are the goals and the objectives of the litigation? What roadmap to get us there, and to be in the same page. But roadmaps, for these type of roadmaps, you got to have flexibility, because things can change very quickly based on a ruling from the court. They can change very quickly based on a deposition that was taken. As information comes in, everything that you have in your case gets reassessed again to make sure that the strategy and the tactics already established will continue in the same path, or it's basically a new strategy has to be developed or modified. But it's important that your attorney has to be on the same page, and also when you agree on that you follow your attorney's game plan. You hire us to do a job, we will do the job, and we're on the same page. It is important for us to follow that game plan. Insisting on unnecessary witnesses or arguments that are not relevant. Again, we're the professionals. We do this every single day. We know what we're doing. Okay, so sometimes you might want to have somebody be deposed for whatever reason, but the attorney may think that, that particular witness is not going to help us. It's not relevant to the case, and it's going to cost us money. So if the attorney feels that that witness is not necessary, then just follow your attorney's advice, because you have to make that assessment. And also, it's a cost involved and a time involved. You got to make a determination, is this witness worth a few $1,000s between deposition preps, the taking the deposition, and also the court reporter? You got to make that assessment. At the end, what is the witness going to contribute to the case that will help your case? So you make that assessment as well. Ignoring discovery or deposition prep instructions is also another mistake. It has happened before. You provide instructions, you prepare for the deposition, and for whatever reason, people sometimes get nervous. It happens. They forget about the instructions, they forget about what we talked about before, and it goes south from there. If you feel you're in a deposition, that you're nervous, that you can ask for a break. Take a break, 5-minute break, compose yourself, and then you just go back to the deposition. Okay. So those things happen, but ignoring the deposition prep or the instructions are not helpful to the case. Another one is happening more often, just because we have ChatGPT and we have more information on the web, is backseat lawyering. I saw online that X, Y, and Z. Or I spoke with a lawyer friend of mine, doesn't practice what you do, but he thought you should do this. So let me talk about those two. Okay. You hire a professional to do a job. And that's what we do. In my case, I have 20 years. So, and we go through a lot of analysis for your case. But if you have a situation where you read something online and give it to your attorney is going to charge you to analyze that piece of information you provided, which for the most part might not be relevant to the case. It might not be helpful to you, especially when dealing with legal analysis. So let your attorney do the job. And if you have factual questions, that's fine. But it's just not helpful to try to be co-counsel with your attorney because he does not need you as the co-counsel. You're the client. Another thing that the second part is more of a pet peeve of mine, which is when another attorney makes comments or opinions on a case that they're not involved with. And usually they're there with good intentions. Happens during the holidays, or they call somebody, they know an attorney, say my attorney does, family law. He thought he should do this in the case. And I said, well, this is business law, business litigation. And they continue. And my response, and I said, I'll tell you what, nobody's taking me up on the offer. I said, tell that attorney, give me his name and number, happy to talk to them, and I'm happy to give them the case. If they know so much about this case, they know the strategy that we should pursue, I'm happy to hand it over to him or her. No, that's fine. They don't want to get involved. And I said, well, then they should not make a comment about the case. Likewise, I get the same questions. I have friends, people ask me, my advice to them, do you have an attorney? Yes. Follow the advice of your attorney. I have zero interest commenting on a case that I'm not getting paid for. So the other attorney should not get involved. And if an attorney is listening to this, I ask you, please don't get involved in my cases. Mistake number 6, being unprepared for testimony or deposition. It's important that you prepare for your deposition, read the documents carefully, because they're looking for inconsistencies that you may have between your interrogatories, your admissions, and your deposition and your complaint. So reading everything, preparing for your deposition is important. It's helpful to your case. Being nervous is normal, is fine, but being prepared is not. So you got to prepare because it is your case, it is for you. And it's important to answer with clarity, short and direct questions, unless you're asked to expand your answer. But listening to the question is very important. Mistake number 7, letting your emotions drive your legal decisions. Listen, all decisions are emotional. Let's be fair about that. Okay, but at the same time, in the business litigation context, sometimes it's about money. And for the most part, it's about money. So refusing to settle because you want to teach the other person a lesson, it's just not a good idea. Refusing to settle out of principle is not a good idea. The idea is to resolve the case. And if you settle it, you're not going to be 100% happy with it, but you're going to have closure. Same thing with the other side. But focusing strictly on an emotional decision is not helpful to the case. And litigating as a principle is not helpful to the case as well. And I'll go over that more extensively in my book. Obviously, commenting about the case in social media is an absolute no-no. Whatever you say within the context of the lawsuit is fine, is protected. Anything outside of the lawsuit is not protected. It's regarding slander and libel. So discussions with your attorney are protected communication. Discussions with your spouse is, spousal privilege. Anything outside that, you might have an issue as well. So commenting about the case, discussing in social media, putting a post, it's not good. So I would not recommend that as well. So these are the top tips that I want to share with you about mistakes you can do or should avoid. Mistakes that can tank your case, and obviously you should avoid these mistakes and at all costs, simply because it can actually hurt you, and it'll be devastating, or could be devastating, if you lose your case because of a mistake that you made. Again, these are mistakes that all of them are avoidable, every one of them. So it's simply applying some common sense, talking to your lawyer, being cooperative, maintaining open communication with your attorney, If you disagree with your attorney in something, let the attorney know, set up a meeting and talk to your attorney. But it's important you and your attorney are on the same page. I think this is good for today. I appreciate you listening to me today. This is episode 97 of Business SOS. If you want to contact me, my email is rich@richsierra.com. If you want to give us a call, the number is 866-842-5202. If you want to learn more about the legal services that we offer at our law firm, my website is floridasmallbusinesslegalcenter.com. Check out the book, Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. If you like a podcast, please share with your friends. We're on Apple Podcasts, Spotify, wherever you enjoy your podcast. We also have the video of this podcast as well at our YouTube channel, at youtube.com/@RichardSierra. Until next time, this is Rich Sierra. Remember that my goal is to help you succeed.